Hello, and thank you for joining us for today's webinar. I'm Angie Elliott, Vice President of Member Engagement and Small Business at the Wichita Chamber, and I'd like to welcome you as we discuss a topic that impacts more than 35 million small businesses in the U.S., including here in Wichita. The Corporate Transparency Act was designed to increase accountability by requiring businesses to disclose certain information about their owners and those who exercise control. As we've talked with area businesses, we find that many are either unaware of the regulations, or we find that they have some important questions about how to comply. So the Chamber is very pleased to partner with Foulston Siefkin to help navigate these requirements. I'd like to thank Foulston Siefkin for teaming up with us on this webinar and for providing their insights. Of the nearly 1,300 businesses in the Chamber membership, 88% are small businesses. As part of our continuing commitment to cultivating strong businesses, we are providing valuable resources to the business community on topics just like today's webinar about the Corporate Transparency Act. Before I introduce our speaker, we have a couple of housekeeping notes. We will have time for questions at the conclusion of Sarah's presentation. So if you have a question, please submit it using the chat function. In addition, we are recording the webinar and we will make it available on the Chamber's YouTube site. So now I'd like to introduce today's speaker, Sarah Buchanan. Sarah is an associate with Foulston Siefkin's transactional and business law practice here in Wichita. She works frequently with LLCs, corporations, and partnerships on a broad range of matters, including mergers and acquisitions, contract preparation and review, financing transactions, creation of business entities, and general corporate matters. She has represented clients on both the buy and sell side of mergers and acquisitions, and often counsels small to medium-sized companies. Sarah, thank you very much for joining us. Take it away.
Thank you very much, Angie. And thank you, of course, to the Chamber for allowing me to give this presentation on this new law that definitely impacts a lot of Chamber members and a lot of clients about the Corporate Transparency Act. So what exactly is the Corporate Transparency Act? At a high level, the Corporate Transparency Act is a filing obligation that requires many entities to file what's called a beneficial ownership information report with the Financial Crime Enforcement Network, which is also referred to as FinCEN. The reports must identify the individuals that own or control the entity, who are called the beneficial owners, and the individuals that formed the entity, who are called the company applicants, with some exceptions. There are relatively steep penalties for failing to comply with the reporting obligations of the Corporate Transparency Act, and this is expected to impact over 32 million companies in the United States. So what exactly is the purpose of the Corporate Transparency Act? It is meant to create a database of entity ownership to allow law enforcement to investigate and punish various crimes, such as terrorism, money laundering, tax fraud, other illicit activity. Prior to the Corporate Transparency Act, there was not just a centralized database of ownership information about various entities. And the purpose of this is to identify the ultimate individual owners of an entity to crack down on people using shell companies to hide behind to engage in these illicit activities. The Corporate Transparency Act was actually passed back in 2021 as part of the annual National Defense Authorization Act. But as we see, it didn't go into effect until January 1, 2024. So for existing reporting companies, which are companies that existed prior to January 1, 2024, these companies have 1 year to file their initial reports. So they have until December 31, 2024 to file a beneficial ownership information report. Now, for new reporting companies, which were formed in the calendar year 2024, they only have 90 days to file their initial reports. And that rule is for 2024 only. After 2024, these entities will only have 30 days to file their initial beneficial ownership information report. So what exactly is a reporting company? There are two different types of reporting companies. There are domestic reporting companies, which are corporations, limited liability companies, or any other entity that is created by filing a document with the Secretary of State's office in the United States. Foreign companies can also be a reporting company if they are a corporation, a limited liability company, or another type of entity that is organized under the laws of a different country, but are registered to do business under the laws of any state. The CTA also includes an other entity catch-all, which means that if an entity is formed by filing a document with the Secretary of State, even if it's not a corporation or a limited liability company, it can still be considered a reporting company, which is subject to the reporting obligations under the Corporate Transparency Act. So let's talk about some examples of reporting companies. Like I mentioned, a reporting company at a baseline level is a company that was formed by filing a document with the Secretary of State's office. So this includes your limited liabilities companies, whether they're single member LLCs or multi-member LLCs, corporations, whether or not it's a C corporation or an S corporation, limited liability partnerships, limited partnerships, and other nonprofit corporations. Now, entities that are not formed by filing a document with the Secretary of State's office are not considered reporting companies. So this includes your ordinary trusts that are created for estate planning purposes, sole proprietorships, and general partnerships. Now, there are several exemptions to the Corporate Transparency Act's definition of what a reporting company is. The CTA lists out 23 different types of businesses that are exempt from CTA filing obligations. So these are entities that are otherwise reporting companies. In other words, they were formed by filing a document with Secretary of State's office, but the Corporate Transparency Act has exempted them from the filing obligations. Typically, most of the categories are in a highly regulated industry or they're already subject to existing reporting requirements. So some examples include publicly traded companies, securities issuers, banks, any government agency is exempt, securities exchanges and clearinghouses, venture capital fund advisors, insurance companies, certain pooled vehicles. And these types of businesses are already subject to reporting requirements, usually at the federal government level, but sometimes at the state government level. So the CTA does not require their compliance because the government already has a lot of information about these entities. There are some other very important exemptions to the Corporate Transparency Act that aren't necessarily industry related. And the four that we'll talk about today are the large operating companies, the tax exempt entities, inactive entities, and the subsidiaries of certain exempt entities. So the first major exemption that we'll talk about is the large operating company exemption. So a company that meets these three prongs, first, having more than 20 full-time employees, which is defined as an employee who works more than 30 hours a week in the United States. Secondly, that the entity's return from a previous year shows gross receipts in excess of $5 million. And if that entity is part of an affiliated group and files as part of a consolidated return, then you can count the entities that are also in that consolidated group for purposes of getting to that $5 million threshold. And finally, an entity has to have an operating presence at a physical office in the United States. So if a reporting company otherwise meets this definition and satisfies all three prongs on this screen, then that entity is not required to file a beneficial owner report under the Corporate Transparency Act. A second major exemption is the tax exempt entity exception. So certain types of tax exempt entities do not have to file CTA reports. So this includes your 501c charitable organizations that are exempt from taxation. And the Corporate Transparency Act carves out a situation where if an organization that is otherwise tax exempt loses that status, they are exempt for purposes of complying with the CTA for 180 days after the date in which they've lost that tax exempt status. Various political organizations that are tax exempt under Section 527A of the Internal Revenue Code are exempt from CTA filing obligations, and certain charitable trusts, which meet the definition under Section 4947A of the Internal Revenue Code, are also exempt for CTA reporting requirements. But this exception does not apply to other not-for-profit companies that are not exempt under one of these specific sections of the Internal Revenue Code. So a common example is most homeowners associations are organized entities that were filed by filing it or formed by filing a document with the Secretary of State's office, but they are not, they do not qualify under any of these Internal Revenue Code sections as a tax exempt entity. So even though it's not for profit, that homeowners association still likely has to comply with the reporting obligations under the Corporate Transparency Act. Another major exemption to the Corporate Transparency Act is this inactive entity exemption. So inactive entities are exempt from filing a beneficial owner report under the CTA. And the CTA's definition of an inactive entity is as follows. That entity has to be in existence on or before January 1 of 2020. It's not actively engaged in business. It's not owned by a foreign person. It's not experienced any changes in ownership in the last 12 months, has not sent or received funds greater than $1,000 in the last 12 months, and otherwise does not hold any kind or type of assets, including ownership interests in any entity. So there is a bit of a distinction between possibly an inactive entity under state law and an inactive entity under the Corporate Transparency Act, specifically the requirement that the entity was formed before January 1, 2020. If an entity has otherwise lapsed its existence with the Secretary of State's office, it might still be deemed an active entity under the Corporate Transparency Act, and it might still be subject to the reporting requirements. And lastly, a major exemption is the subsidiaries of certain exempt entities exemption. So if a subsidiary entity that is otherwise a reporting company, again, meaning it was formed by filing a document with the Secretary of State's office, that entity can be exempt from the CTA filing requirements if it is wholly owned or controlled by an entity that is exempt under the CTA. And this even applies if that subsidiary is wholly owned by multiple exempt entities up the ownership chain. So for example, a subsidiary of a bank would be likely exempt under the Corporate Transparency Act, or a large operating company's subsidiary would also likely be exempt under the Corporate Transparency Act filing requirements. So now I thought we could go over some examples of what are and what are not reporting companies to really show how these rules play out. So the first example is an LLC that is owned 50-50 by a husband and wife that holds residential rental properties. Now, this entity is a reporting company and will be subject to the CTA reporting obligations because it's an LLC, so it was formed by filing articles of organization with the Secretary of State's office, and it doesn't otherwise meet any of the exemptions that we talked about. It's not a large operating company, it's not tax exempt, none of the other industry-specific exemptions apply. So this LLC owned 50-50 by husband and wife is subject to the reporting requirements of the Corporate Transparency Act. The next example is a sole proprietor who operates a food truck. Now, this business is not subject to the reporting requirements of the Corporate Transparency Act because a sole proprietorship is not formed by filing a document with a Secretary of State's office. You do not need to file anything to start a sole proprietorship. So therefore, as a baseline rule, this business is not considered a reporting company under the Corporate Transparency Act. The next example is the corporate manufacturing plant that's located in Wichita, Kansas, that has 50 full-time employees who work more than 30 hours a week and has a yearly gross receipts of $10 million. Again, this entity is at a baseline a reporting company because it's a corporation, but it's the large operating entity exemption applies because it has more than 30 full-time employees, and it has gross receipts in excess of $5 million annually. So this entity is not obligated to file a Corporate Transparency Act report under the large operating entity exemption. The next example is a wholly owned subsidiary of the manufacturing plant that we just talked about. Similarly, this entity is not obligated to file a report because it meets that subsidiary exemption. Since its parent company is an exempt entity for purposes of the Corporate Transparency Act, then the subsidiary also benefits from that exemption and is not required to comply with the filing requirements of the CTA. Next, a church is not a reporting company because it likely falls underneath the tax exempt exception, so it's not required to file its beneficial owner report under the CTA. And then lastly, we have a single member LLC that one person owns that is a hair salon. This entity is subject to the reporting requirements of the Corporate Transparency Act because it's a reporting company, it's an LLC, and none of the exemptions that we've talked about apply to it. So let's talk now about who the beneficial owners of a reporting company are. You'll remember I said earlier that the purpose of the Corporate Transparency Act is to really drill down on who the individuals are that own the entities. So under the Corporate Transparency Act, a beneficial owner is defined as any individual, meaning an individual person who directly or indirectly either owns at least 25% of the reporting company's ownership interests or otherwise exercises substantial control over a reporting company. And like I mentioned, the rule is concerned with identifying the actual individuals who ultimately own the entities. And you have to, there are multiple layers of entities involved in the organizational structure. We're getting to the point where there's an individual that owns the ownership interest or otherwise exercises substantial control. So the first way a person can be deemed a beneficial owner of a reporting company is by owning 25% or more of the ownership interests of that particular reporting company. Now, there are many ways in which this criteria can be met. The Corporate Transparency Act considers direct and indirect ownership in terms of calculating that 25% threshold. So direct or indirect ownership can be shown through either just outright ownership of the company interests, or perhaps joint ownership with another person. So a classic example could be spouses who own ownership interests of a company as joint tenants. They both have rights to that stock, and they could be deemed together to be beneficial owners. If there's a trust that owns interests in a company, that trustee of the trust or even the sole income beneficiary of that trust will be deemed to be the beneficial owner for purposes of the trust. Similarly, if there's a grantor of a trust that owns company interests, then that grantor, as long as the grantor has the right to revoke the trust, is deemed to be the beneficial owner. And then, like I said, ownership interests of the parent company can also be imputed to determine which individual has the beneficial ownership of the company. So, and for purposes of the Corporate Transparency Act, all stock options are also deemed exercised for purposes of determining whether that individual has indirect ownership of a company. So if an individual has the right to purchase stock at some later date, even though that individual might not own any stock today or might not have 25% of the total ownership interest of the company, if that individual has the later right to purchase shares that meet that 25% threshold, then that person is also deemed to be a beneficial owner under the Corporate Transparency Act. The second way a person can be deemed a beneficial owner is by exercising substantial control over a reporting company. Now, this doesn't require the person to actually own any ownership interest of the company. It just means that they have the ability to make decisions about the company, essentially. So the ways that an individual can exercise substantial control. They can be a senior officer of the company. So your C-suite level executives, the president, the COO, CFO, general counsel, et cetera. Even if they don't have that specific title, if they're still exercising the same judgment and have the same control over the company as a president typically would, for example, that person can be deemed a senior officer that has substantial control over the reporting company. If an individual has the authority to appoint or remove certain officers or a majority of directors, that person has substantial control. If that person has the ability to make important decisions about the company, that person can be deemed to have substantial control. And some examples of what important decisions are for purposes of this calculation could be the ability to enter into or terminate substantial business contracts. If that person has the ability to decide whether the company is going to lease, sell, mortgage material assets, if that person can approve major expenditures or approve the incurrence of major debt, if that person has the say on whether the company will go through a reorganization or a dissolution or a merger, or if they have the ability to direct any amendments to the governing documents of that company. So, for example, an amendment to the articles or the bylaws. Those are just some ways in which a person can exercise that important decision-making power over an entity and be deemed to have substantial control over that reporting entity. And the CTA also includes a catch-all provision. So any other form of substantial control that someone could exercise is also enough to qualify someone as a beneficial owner under this example. And now the regulations don't clearly define what that means, but it is meant to be a catch-all provision. So it's intended to capture those people that, might not have the specific rights that we just talked about, but otherwise exercise substantial control. That person is still a beneficial owner of the reporting company. And this is a case-by-case determination based off of the company's governing documents. So if the articles of organization require approval of 50%, for example, if someone has 50% of voting rights over decision-making power, then that person might have substantial control. Whereas maybe in a different set of articles or operating agreement for a different company, the threshold might not be quite as high. So it's a case-by-case determination based off of the company's governing documents. Every beneficial owner report that is filed has to identify at least one beneficial owner through substantial control. And in a lot of situations, you might have a beneficial owner who both owns company interests and also exercises substantial control. But every report requires at least one person to be listed as having substantial control over the reporting company. And there is no limit to how many people can be listed as having substantial control. Reporting companies are required to identify every individual that meets the criteria on this slide of having substantial control. There are a couple exemptions to the definition of who a beneficial owner is. So these people would otherwise meet the definition of a beneficial owner. So they would either own 25% or more of the company interest, or they would exercise substantial control. But for one reason or another, as shown on the slide, they're exempt from being considered a beneficial owner. So this includes minor children. In that situation, a parent or guardian has to be listed in lieu of that minor child. Individuals acting as agents on another behalf. So if a CEO, for example, has a tax advisor or a lawyer who helps influence decisions, or at least talks to the CEO about what decisions to make and would be beneficial for the company, that person is acting solely as an agent of that CEO and is not considered a beneficial owner. Any employees of a reporting company who don't otherwise have a position as a senior officer and who are acting solely as an employee aren't deemed to be beneficial owners and do not need to be listed on the report. Individuals whose only interest is a future interest through a right of inheritance are not beneficial owners until that person actually receives the inheritance. So for example, if they receive company interests as part of their inheritance, then at the point in which they receive those company interests, they become a beneficial owner, but not prior to receiving that inheritance. And lastly, creditors are not beneficial owners, even if the creditors, by the terms of the creditor loan agreement, have some rights to direct or control the business. We'll go through some examples now of different organizational structures to highlight who are beneficial owners and who might be subject to the reporting requirements. So in this example, we have a reporting company that is owned by 5 different individuals. Individual A owns 27.5% of the reporting company. Individual B owns 35% of the reporting company, and then individuals C, D, and E each own 12.5% of the reporting company. And you'll notice there's also a CEO of this reporting company. So the highlighted individuals are the ones that are beneficial owners under the Corporate Transparency Act. Individual A and individual B both own more than 25% of the total interests of the reporting company. So they are deemed to be beneficial owners by virtue of owning more than 25% of the company. And additionally, the CEO is deemed to be a beneficial owner of the company because that person exercises substantial control over the company by virtue of being a senior officer. Likely the CEO also has important decision-making power, so there could be multiple ways in which the CEO is identified as having substantial control. So in this structure, you have the 3 individuals that are highlighted who are considered beneficial owners and will be listed on the beneficial owner report. Now, individuals C, D, and E don't need to be listed on the report because they only own 12.5% of the ownership interest. The caveat to that, though, is that if individuals C, D, and E otherwise exercise substantial control over the entity, despite not owning 25% of the entity, those individuals might still nevertheless be required to be listed on the beneficial owner report. Again, that is a case-by-case basis. Here is a slightly more complex example of what an entity structure might look like. In this example, we have 3 owners of the reporting company. Owner A is a revocable trust, and there is a grantor of the revocable trust, and the trust owns 30% of the reporting company. Owner B is a single member LLC that owns 50% of the reporting company. And because it's a single member, it only has one owner. And then the last owner is just an individual who owns his or her interest outright, and they own 20% of the reporting company. Now we also have a three-person board of directors, so director A, B, and C. In this example, the highlighted people are going to be deemed beneficial owners. So the grantor of the revocable trust that owns 30% of the reporting company interest is a beneficial owner because the grantor has indirect control over the company interest of the reporting company by being the grantor and maybe likely the trustee of the revocable trust. Owner B must report its owner. So the owner of the single member LLC that owns 50% of the reporting company is the individual that will be identified on the beneficial owner report for the same reason, because it exercises indirect control over the reporting company by owning 100% of the entity that owns 50% of the reporting company. And lastly, again, a case-by-case basis, the directors A, B, and C might be required to be listed as having substantial control depending on what the director's role with the company are. And some companies, the directors take a really active role and have say over important decision-making aspects of the company, which makes them probably have substantial control and they need to be listed on the beneficial owner report. But in some companies, the directors serve more as an advisory role and might advise the senior officers or maybe the owners of the company, but don't have the ultimate say on what decisions the company makes. So again, you have to look case by case basis to determine whether or not a director has substantial control over the company. Now, this is the most complicated example that we're talking about, and it's the same structure as the one we just talked about. The only difference is that owner B, which is the LLC that owned 50% of the entity, is now a multi-member LLC, which is owned by 3 individual members. So member 1 owns 60%, member 2 owns 25%, and member 3 owns 15% of the LLC that owns 50% of the reporting company. So this is where it gets a little bit complicated under the CTA. Like we talked about, we have the grantor and each of the directors highlighted as individuals that are beneficial owners, either by virtue of having ownership interests or by exercising substantial control. But it gets complicated when you look at the individual members of the LLC that owns the reporting company interest. So the under the CTA, the way that this analysis works is that you need to look at the ultimate individuals that own the LLC. So we would say member 1 owns 60% of the LLC that owns 50% of the reporting company. So under the CTA, you multiply the ownership percentages of both of the entities to determine what member 1's ultimate indirect ownership percentage of the reporting company is. So I've done the math over here on the side, but member 1 owns 60% of the LLC, which owns 50% of the reporting company. So under the CTA, member 1 is deemed to own a 30% indirect interest of the reporting company, which is, of course, over the 25% threshold. So that person is a beneficial owner of the reporting company and will be listed on the beneficial owner report. Now, members 2 and 3 do not meet that threshold, despite member 2 having 25% ownership in the multi-member LLC. When you multiply that by the ownership interest that the LLC owns of the reporting company, member 2 only has 12.5% indirect control over the reporting company, is below that 25% threshold, and therefore is not a beneficial owner. Same with member 3, that person only owns 7.5% of the indirect ownership of the reporting company and is not a beneficial owner. And of course, on this example, you also have owner C off to the side who only owns 20%. So that person was never required to be listed as a beneficial owner, just by virtue of owning less than 25% of the ownership interests. So now we're going to talk a little bit about company applicants. I mentioned earlier that the beneficial owner reports will include 2 types of people, the beneficial owners of the company, and then also the people who actually form the entity. So who are the company applicants that must be included in the report? For a domestic reporting company, this is the individual that directly files or directs the filing of a document that creates the reporting company. So for example, I frequently form entities for clients. I direct the filing and the formation of an entity, and I oftentimes will have a paralegal hit submit on the formation documents with the Secretary of State's website. So I would be considered a company applicant because I directed the filing, and the paralegal would also be considered a company applicant because she submitted the document that created the entity. For foreign reporting companies, this is the individual who files the document that registers the reporting company with a state in the United States. And of course, anyone who also directs that filing. Every beneficial owner report allows up to 2 company applicants to be identified. And any reporting company that existed before January 1, 2024 does not need to include company applicant information. So if an entity was formed in 1985, there's no obligation for that company to go back and figure out who actually formed the entity back then and put that personal information on the report. It's only for entities that are formed after January 1, 2024. So let's talk about the actual contents of the beneficial owner reports and what information will be included in them. So you have the company information, the legal name of the company, any trade name or doing business as name that the company might use, the business address, the jurisdiction of formation, if it's a domestic company, or the jurisdiction of registration, if it's a foreign company, and additionally, the company's taxpayer identification number. In the instance of like a disregarded entity, so for example, a single member LLC, usually the taxpayer identification number of that entity is the owner's social security number. So in some contexts, the taxpayer identification number might end up being the owner's social security number, unless of course that company has a taxpayer identification number separately. And in addition, the report will include information about the beneficial owners and the company applicants. So the people who either own 25% or more, or exercise substantial control, or otherwise formed the entity. And the information required for these people are the legal name, their date of birth, their residential address, except for company applicants can use their business address if they routinely form businesses. And that there has to be an identifying number from a form of identification document. So that can be either a non-expired US passport or an otherwise non-expired state or local government issued document. So the common example is a driver's license and also a non-expired foreign passport if none of the other options are available to that individual. And you must also include a picture of the document described in number 4. So when we file these reports, we typically take the driver's license as the identifying document. So we upload the driver's license number and also a picture of the driver's license with the report. Now, the CTA imposes continuing obligations for reporting companies to update their beneficial owner reports. Beneficial or reporting companies have to file updated reports within 30 days of certain events happening. So if there's any change in the beneficial owners, so if there's a new owner or an owner is no longer an owner of the company, an updated report is required to inform of the change of ownership. Similarly, if someone who had substantial control over the entity no longer has substantial control, or a new person joins that has substantial control, an updated report is required to inform of the change. And if there's any change to the beneficial owner's personal information. So like we just talked about, company applicants and beneficial owners have to include their name, address, driver's license document. So if that individual moves or changes their name or gets a new driver's license, then there's an obligation to update the contents of the report to match the most current information. And finally, if there's any change to the reporting company information. So for example, if the reporting company changes its name or moves business addresses, et cetera, there's an obligation to file an updated report. The obligation to file an updated report begins once that reporting company files its initial beneficial ownership information report. So As an example, if an entity existed prior to January 1, 2024, and it filed its beneficial owner report in, let's just say, May of 2024, that obligation to file the updated report starts as soon as that initial report was filed. So even though the entity's deadline for purposes of the CTA to file its initial report was the end of 2024, the obligation to file updated reports starts as of May of 2024. And a reporting company may not be required to file an updated report when the company applicant information changes, unless the reporting company has reason to know that the information is incorrect. So in the example I gave earlier, I'm typically a company applicant for a lot of our clients that we form entities for. The reporting company has no obligation to stay apprised of my information and file an updated report if any of my information changes, unless, of course, that reporting company had a reason to know that the information we provided was wrong for some reason. And if a reporting company learns of any inaccuracy in its report, it has 30 days to file an updated report. And we talked about some events that might require an updated report, but there are a lot of events that most people might not think about that also require an updated filing. So this could be any merger or acquisition. If you have people buying and selling their interest in the company, or if you're bringing in new officers as part of the merger and acquisition, there's likely a change to the beneficial owners, and that requires an updated report. If an individual transfers their ownership interest in a company to a trust, now you might have another trustee that's part of the trust that will be deemed to have indirect control over the reporting company based off the definition under the CTA. Of course, if a senior officer is hired or fired, that would trigger an updated report. If a company issues new shares, so maybe someone didn't have quite 25% ownership of a company, and then the company issues additional shares and bumps that person up over the 25% threshold, they are now a beneficial owner and the report needs to be updated. Similarly, if a shareholder who otherwise is a beneficial owner has their shares redeemed, that causes a change that will need to be corrected on the report. And then, of course, we've already talked about any changes in name or address, whether that's for the reporting company itself or any of the beneficial owners. FinCEN is allowing individuals to obtain what's called a FinCEN ID as an attempt to expedite the reporting process. So as of January 1, 2024, any person who would be a beneficial owner or a company applicant can obtain a FinCEN ID, which is a unique identifying number that FinCEN issues that can go on the report in lieu of the personal information. So instead of having a beneficial owner that on the face of the beneficial owner report lists out their name, their address, their driver's license, for example, that person can instead go preemptively and obtain a FinCEN ID in which they provide all that information to FinCEN and get a number in exchange. And then the only piece of information that goes on the report for that section of that beneficial owner is that FinCEN ID. And the information is the same as what would be on a beneficial report. So that person's legal name, date of birth, address, and then their driver's license or passport and a picture of that. And if an individual has any change to the information, instead of requiring the reporting company to then file a corrected beneficial owner report, that person can update that information just in the context of their FinCEN ID, which also helps expedite the reporting requirement. So individuals have 30 days to update any change to any information that we've talked about that is required to get a FinCEN ID. Similarly, they have 30 days to correct any inaccuracy in any information. So let's talk now about the penalties of failing to comply with the Corporate Transparency Act. So it's a reporting violation to include false or fraudulent information in a beneficial owner report. So it is unlawful for any person, whether that's an individual beneficial owner or the reporting company or other entity, to willfully provide or even attempt to provide false beneficial ownership information. And this can be either information that is directly provided to FinCEN. So, a person fills out their beneficial owner report and includes false information and submits it to FinCEN, or if a person provides incorrect information to someone who is filing the beneficial owner report on behalf of that person. Both of those are considered willful failures to provide correct information. So unlawful, like I said, it's unlawful to willfully fail to report complete or updated beneficial ownership information. And a person is deemed to have done so if that person fails to file the report causes the failure to file the report, or is also a senior officer of the reporting company at the time of the failure. So if you have a senior officer who might not be involved in filing the CTA report at all, and for some reason the CTA report is filed late, just by virtue of that person being a senior officer, they are deemed to have failed to comply with the CTA requirements. So like I said earlier, the CTA imposes pretty steep penalties on individuals who fail to comply with the CTA. So the regulations say that violators shall be liable for civil penalties of up to $500 every day that the violation continues, which has since been adjusted to $591 to account for inflation. So, if a new reporting company formed in 2024 has 90 days to file its existing or its initial beneficial owner report, for every day that filing goes past 90 days, the penalty is $500 for every day that violation continues. Even if it was not a willful violation, if someone just didn't know that they had to comply with the CTA, the penalties are still imposed. For willful violators, so for people who provide false information or deliberately do not comply with the CTA filing requirements, those individuals may be fined up to $10,000 or might even be imprisoned for up to 2 years or have both consequences as a result of that willful violation. Now, the CTA does include a safe harbor provision that says that a person shall not be subject to any civil or criminal penalties if that person has reason to believe that a report contains inaccurate information and has submitted a corrected report within 90 days. So if you remember earlier, I mentioned that reporting companies and beneficial owners have 30 days typically to correct any information that they know is inaccurate on a report. This safe harbor provision says that, even though if we're like in the 60 to 90 day range, even though that person is technically not complying with the deadlines imposed by the CTA will not impose penalties on that person as long as that person submits a corrected report within 90 days. And this safe harbor is inapplicable to anyone who intentionally avoids reporting or is otherwise willfully failing to comply with the terms of the CTA. A hot question that a lot of people have is what is the government doing with this information and who has access to the information? So FinCEN says that the information is stored in a secure database that's not accessible to the public and that it has the same level of security as any database maintained by any other federal agency. The beneficial owner information is not publicly available and it's only accessible to certain groups, which includes federal law enforcement agencies or agencies that are engaged in national security or intelligence. State law enforcement agencies can request BOI information only if they have a court order authorizing them to do so, and it's all in connection with a criminal or civil investigation. So the information is even withheld further from state agencies than it is from federal agencies. It requires that court order and also to be in connection with some ongoing investigation. Financial institutions, including banks, can access beneficial ownership information or report when they're completing customer due diligence if they have permission of the reporting company to do so. So without the permission of the reporting company, authorizing that bank to ask FinCEN for that reporting company's information, financial institutions do not have access to the beneficial ownership information. And federal and state regulatory agencies that advise financial institutions, so banks, for example, on customer due diligence requirements, also can access beneficial ownership information without a court order. But FinCEN requires every agency that is requesting beneficial ownership information to enter into a memorandum of understanding with FinCEN that lays out exactly how the agency intends to protect the confidentiality of the information and ensure that it's not subject to any leaks or et cetera. So another hot topic is whether or not the Corporate Transparency Act is constitutional. So as soon as the Corporate Transparency Act went into effect, the National Small Business Association filed a lawsuit against the Department of Justice alleging that the Corporate Transparency Act was unconstitutional. A federal judge in Alabama on March 1st of this year actually held that the Corporate Transparency Act was unconstitutional because it was an improper exercise of congressional power. In other words, the breadth of the CTA by requiring 30 million companies to report was not a necessary or proper means in achieving Congress's policy goals to eliminate and investigate crime. Now that case applies only to the plaintiffs in that case, which is the members of the National Small Business Association, and it only applies to the business members of the association. So those entities that are members of the National Small Business Association are not reporting companies, and FinCEN cannot enforce the terms of the Corporate Transparency Act against those entities. The Department of Justice has appealed the ruling. They issued their notice of appeal on March 11th. And currently the matter is on appeal in the 11th Circuit Court of Appeals. I know that the National Small Business Association just filed its brief about a week ago. So I think we're still a little bit further out from knowing what the ruling on this case will be. But as of today, the Corporate Transparency Act is still in effect and compliance is still required for anyone who is not happened to be a plaintiff in that case. So if they were not a member of the National Small Business Association when that ruling was enacted. And the future of the CTA is honestly uncertain at this point. You know, we're keeping an eye on developments, but until it works its way through the court system, it's hard to say if the Corporate Transparency Act will be constitutional or not. But for now, entities should just assume that they are required to comply. As you know, like we talked about, there are penalties if you don't. So I would not hold out on the hope that maybe it's overruled as unconstitutional, because that could take a very long time if it ever happens. So just to recap what we talked about, these are kind of the steps that you'll want to go through when you're thinking about your particular entity to determine whether or not it's subject to the reporting requirements of the CTA. So the first question you'll ask is, when was the entity formed? If the entity was formed prior to January 1, 2024, that entity has all through 2024 to file its report. So it won't be due until December 31, 2024. If the entity was formed after January 1, 2024, then that entity has 90 days for 2024 to file its report. And then, you know, once we get into 2025, that deadline is cut down to 30 days. So any entity formed later in 2025 will have only 30 days to file its beneficial owner report. The second question you want to ask is whether or not the entity is a reporting company. So remember, as a baseline rule, a reporting company is an entity that is formed by filing a document with the Secretary of State's office. So your LLCs, corporations, certain partnerships are reporting companies at a baseline. And in contrast, sole proprietorships, usually your general partnerships aren't formed by filing a document with the Secretary of State, and those entities are not reporting companies. So if you've determined that the entity is a reporting company, then the next step is to look at the 23 different exemptions and determine if any of them apply. So, you know, we talked about some of the bigger ones, the large operating company exemption, the tax exempt entity exemption, inactive entities, and subsidiaries of exempt entities. But there might also be industry related exemptions that apply. So as a reminder, banks are subject to that, securities issuers, and various types of businesses that are already pretty highly regulated or otherwise subject to reporting requirements may be exempt under the Corporate Transparency Act. So if you've determined that the entity is a reporting company and an exemption does not apply, the next step is to determine who the beneficial owners of the company are. And people can be deemed a beneficial owner either by owning 25% or more of the company interests or by exercising substantial control. And like we've talked about, that is a very case-by-case analysis on determining whether someone exercises substantial control. And then, of course, you know, once you've determined that your reporting company is subject to the requirements and you've identified who the beneficial owners are, then of course, the next step is to file that beneficial owner report within the prescribed deadline for your entity. And lastly, I would also encourage you just to stay informed on the status of the CTA as it makes its way through the court system. That way, you know, if you're required to comply with the requirements and maybe, you know, what the deadlines are for that. So this is a list of some helpful resources that I frequently turn to when I'm, you know, learning about Corporate Transparency Act stuff or just trying to keep on top of new developments in that area. So the first is a link to the actual filing portal on FinCEN's website. So this is the link you go to if you want to file a beneficial owner report. It's a very helpful resource because it includes updates about CTA litigation. And unfortunately, there have been several scam attempts related to the CTA. There will be people who, solicit others to try and get them to agree to file their beneficial owner report or various things. So just at a high level, I think this is a good website to go look to just see what's going on with the Corporate Transparency Act and kind of stay up to date on current events with respect to it. And the reports are free to file just by yourself. Of course, if you hire a service to do that, then you'll pay the service fees for doing that. But in terms of just filing a report on FinCEN's website, it's free to do. And the next two links are just resources that have been issued by FinCEN that I think are very thorough and very helpful. So the first one is just the FAQ page on FinCEN's website. It's very thorough. It goes over pretty much any question you could have about the CTA. If you have questions, I encourage you to check that out. Additionally, FinCEN's Small Entity Compliance Guide is drafted more directed towards small businesses and letting them know what their reporting obligations are and just kind of the ins and outs of the Corporate Transparency Act. So that is all I had prepared. If there are any questions, I'm happy to chat about those now.
Thank you, Sarah. I don't see any questions in the chat, but we may give folks a couple seconds to think about it. And of course, if they have questions after this, I'm sure they could reach out to you and you can direct them to the correct resource.
My phone number and my email address are on the screen. If you do have any questions after the fact that come up, I'd be happy to chat with you about that.
Okay, wonderful. Well, seeing no questions, hopefully gave people a lot to think about. We certainly do appreciate that really informative presentation and those great resources. We appreciate you sharing your expertise and your time today. Oh, wait. There's a question. Hang on. Oh, okay. How long does it take to complete the CTA forms?
So it really depends on how complicated your filing is. For a single member LLC, we've done several of those. It takes just honestly a few minutes. If you have all of the information available, you're really just putting in that personal information. But of course, I mean, as you've seen on some of the examples, it can get pretty complicated depending on the entity structure. So we have clients who it takes much longer than just a few minutes to fill it out. And you got to make sure that you have all of the information from every one of the beneficial owners too. So in my experience, that can also delay the filing process a little bit, just gathering all that information from everybody. So the answer is it really just depends on how complicated the structure is and how many individuals you have to report on the form.
Okay. Good question.
Mm-hmm.
But regardless, you have to do it, right?
Yep.
Okay, let's see here. Yes, so we'll just go ahead and wrap up there. Just want to remind everybody that we will be posting this recording on our on the Chamber's YouTube around 4 o'clock today. Probably we'll edit a couple of things at the beginning and the end, and then we'll get it posted up there. So once again, Sarah, I want to thank you for your time. Appreciate Foulston Siefkin, long-term partner of the Chamber. I really appreciate your supporting of these initiatives. So thank you, everybody, for joining us.
Thank you, everyone.